Case number 111556, State of Kansas v. Jose Solis. You may proceed. Thank you.
Good morning. May it please the Court, Carol Longenecker-Schmidt of the Appellate Defender Office representing Jose Solis. Chief Justice, I would like 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Just to offer the brief 60-second factual summary, and I'll face the microphone instead of the students because I don't have a particularly loud voice. But Mr. Solis was convicted of a jury trial, or convicted of first-degree murder, premeditated murder, after a jury trial. He was convicted for killing his former girlfriend, Natasha Crump, on December 23, 2006. Police found Ms. Crump's body in Mr. Solis' apartment. She was in a bedroom, and she had been strangled and had scratch marks on her body. Mr. Solis claimed that on the evening of December 22nd, 2006, he was at work and he came home. He went to a friend's apartment to drink, and then he went on a side trip to a nearby town, and then he came back, and Ms. Crump was at his apartment. They got into an argument, and he admits that the argument got physical, after which he said that they had sex, and then he went to sleep on the couch in the apartment, and that's the last time that he saw Ms. Crump alive. There were the issues in this case. There are 3 instructional issues and 1 evidentiary issue that really encompasses kind of 2 different types of, or 2 different pieces of evidence that were admitted in error. And unless your honors prefer otherwise this morning, I'd like to start with the 3rd issue in the brief. That is the issue about the giving of lesser included instructions. This issue is really about the application of the 2011 amendment to the culpable mental state statute to the giving of lesser included offense instructions. A district court judge must instruct on lesser included offenses when there is some evidence that would allow a jury to reasonably convict of those lesser included offense instructions. In 2011, the legislature amended the culpable mental state statute to state that proof of a higher degree of culpability than the crime charged constitutes proof of the culpability charge. If recklessness suffices to establish an element, then so does intentional conduct. So, with this amendment, the inference is that when there is evidence at trial that a defendant acted intentionally, therefore there is always evidence that the defendant also acted recklessly. And the logical conclusion here is that if a defendant is charged with intentional murder, he or she would always be given the reckless forms of homicide, so reckless, unintentional second-degree murder, and involuntary manslaughter.
And that statute that makes proof of intentional also proof of reckless was not in effect in 2006 when the crime occurred.
Yes, that's what the state is arguing.
And wasn't that part of the entire rewrite of the criminal code?
Yes, so the subsection C of 215202 was added in during the recodification.
And that recodification was accompanied by, and I can't remember the statute number, but that says this new code will apply to crimes that occur after its adoption. And in making that determination, if any substantial element of the crime has been committed before the effective date of the code, then it's under the old code. In other words, there was a statute that accompanied the adoption of the new code that basically made the new code only effective after its adoption.
I am not familiar with that. My argument in the reply brief was that this is merely a procedural change to the law.
But we don't have to go there if we have an express statement by the legislature.
I think that that's the correct analysis. That yes, if the legislature says prospectively,
yeah.
then you don't have to go there. Another way to view this would be that Mr. Solis's case is it's not final; it's still pending. Maybe talking about retroactive application isn't even quite the correct phrase here. Because his case is not final, and the statute came out while his case was pending. So I think that, that's the argument that we would rely on at this point. The state in its brief talks about the statute not applying.
Counselor, it's 215103D, if you may want to look at that, is the statute that I'm telling you that made the code not applicable to crimes committed prior to July 1, 2011. That seems like a pretty big hurdle for you to clear on this.
Yes, Your Honor, that could be a burden. I have not read it, so I can't comment. I could sit down and try to comment further on rebuttal for you. So I don't think I have
But your
any more.
position is if it does apply, or somehow you can get to it, get that it does, is that in this type of situation or in any homicide case, second-degree reckless would always be given as an instruction, or what do you?
Yes.
Always.
If there's proof of intentional conduct, then that necessarily requires instructing on reckless. Yes.
So basically now in any homicide case, a judge is required to give basically every lesser, maybe not voluntary because that's a different, but at least in terms of your position would be that premeditated first-degree murder, second-degree murder intentional, second-degree murder reckless, and then involuntary.
Yes, that
Would have to be given.
Yes, that is my position.
And if this crime had taken place in 2011, that would be your position.
Yes, that's
All right.
I understand the argument as to why your argument as to why all of those lessers would be legally appropriate. In other words, as I understand your argument, the elements sort of nest inside one another, and so it's always legally appropriate. Can you address the second prong of that, though, as to whether or not a district court has some sort of gatekeeping function to determine whether or not the lesser is factually appropriate?
I think that the amendment to the statute also explains why it would be factually appropriate, because the statute, the first word is proof of a higher degree, so it's talking about evidence. I think it's saying that when there is evidence of intentional conduct, that factually that means there's also evidence of reckless conduct. I think it's I think it's saying that.
It's saying that the evidence would be sufficient to
Yes.
support the lesser culpable state.
Yes, that's my argument.
But tie that in for me to the statute on lesser includeds, which requires that the district court determine that a jury would be reasonably justified in convicting on the lesser.
Right, I think the jury would be if the district court judge had both of these statutes in front of him or her, read them together, and some evidence that the jury would rely on to reasonably convict would be, if there's evidence of intentional conduct, it has to be reckless because of the second statute. So presumably, let me take a step back. If a jury had all of the homicide instructions, except for perhaps involuntary or voluntary manslaughter, they would also have an instruction, the PIC instruction, that explains this, that explains that proof of intentional conduct results or proves reckless conduct, and that therefore would allow a jury to reasonably convict a person when there's only intentional conduct presented at trial of a reckless offense. So I think the instruction, the PIC instruction that would accompany these lesser included instructions, that brings us back to the initial statute, and that would give a jury some evidence to convict.
Just to summarize, your argument is anytime there's some evidence or sufficient evidence, then a jury would be reasonably justified at convicting.
Yes.
Right, okay.
Yes.
Can I take you back to the 6455 evidence?
Yes.
This was the second trial, and at the first trial there were some objections, some rulings made. The evidence that you're complaining about now was offered at the first trial,
I believe it was.
and that trial counsel stipulated that that basically was going to be the parameters of the court's order in limine at the second trial. It's my
I don't-
understanding that there was no objection beyond what was done at the first trial. Counsel agreed that the evidence that was offered at the first trial could be offered at the second trial.
Oh, I'm not aware of that, Your Honor. My recollection is that, let's see, at the pretrial conference before the second trial, they referenced pretrial rulings and orders that were made before the first trial. I'm not aware of a stipulation.
Well, I don't think it was a stipulation. I think they agreed that the trial judge's previous rulings would govern the second trial. Are you trying? There wasn't any objection to the second trial, right?
Right.
And so we have a preservation
Right.
problem.
Right.
How do you get over that? Do you say that agreement that the judge's rulings at the first trial are going to govern at the second trial is tantamount to a continuing objection, or how do you get over the problem of no objection to the second trial?
Yeah, that was not my argument. When they were referencing the first trial, I thought they were just talking about pre-trial rulings, not any sort of objections or stipulations that happened at trial. My argument about preservation for the first issue is largely that the admission of propensity evidence is a due process violation. And I'm aware that this court has refused to apply the exceptions to you can't raise a rule or an issue for the first time on appeal. But typically this court does not apply those to evidentiary issues. But my argument would be that this is a due process violation, and that Mr. Solis should be able to apply this or raise this for the first time on appeal. This court has in the past treated the admission or the erroneous admission of propensity evidence as a due process violation, not for preservation purposes, but when looking at whether the admission of that evidence was reversible, so applying the Chapman harmless error standard. So there was an assumption there made that the admission of propensity evidence is a due process violation, but I don't think a full analysis was ever
And which
done.
specific evidence? Now, some evidence was withheld, suppressed. The evidence of a prior conviction and some other evidence. Your client conceded to the evidence of what happened in December, right? Or that wasn't objected to, the evidence of what happened in December, the date of the month of killing. So we're talking about some events that happened before December, but I was a little unclear specifically what evidence that you were talking about.
Okay, I hope I can clarify. So there's two pieces of evidence or groups of evidence. There's evidence of batteries, domestic batteries that occurred before December 2006. And that evidence came in a trial through Richard Kaufman, I believe. And he testified about Ms. Crump coming to the restaurant, and he would see bruises on her arms and ask what happened. And she said, Mr. Solis was throwing me around again. And the time frame that she was talking about occurred before December 2006. And that evidence was excluded at trial. The district court said that seems a little too far removed or remote. So if you want that to come in, we need to have a full 60-455 analysis at trial. So that was the order going into trial, and that evidence came in. The second group of evidence is evidence of,
And it came in without objection.
that's correct, yeah, so there's a preservation problem with that, but that evidence was supposed to be excluded. Came in without objection. And then the second group of evidence is evidence that's essentially the same thing, the bruising, that Mr. Solis caused bruising on Ms. Crump's arms during the week leading up to her death, so in December 2006. And that the district court conducted a full 60-455 analysis on and said it could be admitted. No objection. I'm claiming that both of them came in erroneously. So I will, unless your honors have further questions, I'll conclude my argument. Thank you.
Thank you, counsel.
May it please the court, the state appears by Stephen Obermeyer. I'll address the same two issues in the same order unless the court tells me otherwise. As far as issue 3, whether or not a lesser instruction should have been given for unintentional, reckless sort of homicide, the state's position is that that's neither legally appropriate nor factually appropriate under the facts of this case. As far as the legally appropriate, the legislative change of the statute went into effect in 2011. It was actually passed by the legislature in the 2010 session. And the second jury trial in this case was held in January of 2010. So we're basically faulting a trial judge for not predicting that there's going to be a change in the law that's going to change 215202 about lessers, and instructing the jury on it for a 2006 crime. And that is why the state's initial argument is that you always look to the law that's in effect at the time of the crime.
Unless you're arguing that there should be no lessers for felony murder.
Under the lesser statute, that's correct.
And if the legislature can redefine felony murder to eliminate any lessers, say it doesn't include lessers, why isn't there redefinition of reckless to include intentional also of the same ilk to be applied retroactively?
Because I think the ilk of the what's a lesser statute was deemed procedural in whatever case it talks about it, where here we have a substantive change in the law as far as what the elements of the crime are and what the penalties of the crime are. So I think that would be one difference in that, at least as far as the legal argument and the statute. The new criminal code, as the court pointed out under KSA 215103D, states that this code has no application to crimes committed prior to July 1 of 2011. So I think legally it would not apply, that legislative change, and nor would it apply factually, just because of the nature of the homicide in this case, which was a strangling. And the coroner testified that it would take between 6 to 10 minutes to strangle someone, or for a person with a ligature to die. And here we have some resistance by the victim who was fighting the assailant. So it would take longer than 6 to 10 minutes for that to happen. So under reckless conduct, could somebody recklessly engage in a conscious disregard of the risk of strangling somebody and a gross deviation from the standard of care to make that a reckless homicide? And just under the facts, I don't think you can get there that it's not factually appropriate. And I think the Killings case is supportive as far as you look at the facts of the case to see what happened. And here we have the defendant's mother of their 2-year-old who wakes up on Saturday morning and doesn't know where his wife is, or girlfriend is, ex-girlfriend. She was basically staying there because she lived, that apartment was close to where she worked. He doesn't call her directly to see if she's at work that morning. He's calling her sisters and other people to see if they know where she is. And then lo and behold, he finds her dead in his bedroom. And although his DNA is all over her, somebody else must have done this. And so factually, it is not a reckless sort of homicide. And his fingerprints were on a Christmas card that she had received from a coworker saying that Natasha, you rock. And his fingerprints were all over her cell phone, so he was checking that out. And then his story as far as where he was that Friday night did not pan out as far as the cell phone evidence and the other evidence. So it wasn't factually appropriate. The last argument on that would also involve the skip rule. The jury was instructed on intentional second-degree murder as a lesser of premeditated first-degree murder, and the jury did not go down to second-degree intentional murder. Reckless second-degree murder would have been an even lesser degree of a crime, and so under the skip rule, the jury would not have even gotten there. With regard to the first or second issue, as far as the 6455 evidence, there was a prior trial in this case in February of 2008. The second trial occurred about 23 months later in January of 2010, and at one of the pretrial conferences before the second trial in volume 25, the state says we're operating under the assumption that all the rulings in limine and rulings on the motions that were made before the previous trial still applied, and the state was going to basically abide by those rulings, and defense counsel acknowledged going with the 6455 and other motions. We understand we are going forward just like we are doing the trial over with the identical rules that we had the last time. And so in both trials, the evidence of the bruising witnessed by the victim's sister and by a coworker was presented to the jury at both trials without objection.
But
Do
there
you
were
agree-
objections, excuse me.
Do you agree that there was a different ruling as to the earlier bruising observed, and that only certain evidence that was closer in time to the crime was supposed to come in?
I agree that the order did say that that December 2006 bruising was admissible, and so that would relate to the sister's testimony. As to the coworker Richard Kaufman testimony, the question was asked that during the 4 months leading up to Natasha's death, there were times that she'd come into work and have marks on her arms. That would apparently be outside of the court's order in limine, and I was trying to figure out how that happened, and I would direct the court to the state's motion to admit the evidence of discordant relationship pursuant to 6455 in State versus Gunby. It starts at volume 1, page 142. And at page 143, there's a big paragraph where the state makes a proffer of what its evidence is going to be, and it says that Mr. Kaufman saw bruises on Ms. Crump's forearms in December of 2006. And so I think that's where that came from, because in Judge Ruddick's order, and this is at volume 1, page 148, the court ruled that the evidence specifically described in the state's motion took place in December 2006, and this evidence is admissible. So I don't know if that's how it got there, but at any rate, if it was an order in limine, it should have been objected to at the first or the second trial to clue in the state that, hey, maybe this is outside the court's order in limine, and it wasn't.
Well, did it come in differently at the second trial? I mean, I seem to recall that at the first trial there were some defense objections.
I don't recall
Okay,
if that came
all
in at the with over objection at the first trial. My recollection, it wasn't, but it might have been. But certainly it wasn't objected to at the second trial, and nor was it instructed in the second trial or the first trial. So we're into whether or not it was clearly erroneous to not give the 6455 instruction.
So you concede error.
Yes, I concede that State versus Gunby says that it should have been given, and the failure to give it would be reversible if clearly erroneous. And the evidence, as to this, the evidence from the sister, I think you had the 6455 analysis, and I think from Judge Reddick's order that the December 2006 evidence, that it would kind of cover both of those. But if you look at State versus Gunby, the victim had been strangled to death and was found in Gunby's, I think the trunk of Gunby's vehicle, and the prior strangling evidence came in under the analysis. And in this case, you have prior bruising prior to the strangling in December of 2006. So that evidence would have come in. And in addition, if you look at all the other evidence, the relationship evidence that came in that wasn't 6455, that's what would make this not clearly erroneous or would make this harmless error. And I'm talking about the evidence where the owner of the restaurant, the Mustache Cup, told the defendant, quit coming over here and bothering Natasha. I'm ordering you not to come back here. And then he would come back and be across the street or across K7 trying to harass her. And there was an incident where friends were leaving this restaurant and the defendant's there to confront Natasha previously. So there was other evidence where that came in. In addition, if you look at the state's closing argument, the state did not argue that Solis was a general wrongdoer who deserved punishment because of these bruises and that he had a propensity to commit crime. In fact, I doubt a juror would say, you know what, I'm not sure if he committed the murder, but by gosh, she had bruises on her arm, so I'm going to find him guilty because of that. I don't think that is how a juror would analyze that evidence on a serious charge like the first-degree murder.
Mr. Obermeyer,
Yes.
do you mind if I redirect you to go back again to the issue of the statute and its effective date on intentional versus reckless and all of that?
Sure.
I just want to kind of walk through this in my mind a little with you, how I'm thinking about it. You know, both you and your opposing counsel brought up the idea of whether it was a procedural or a substantive change. And it seems to me that matters only when the discussion is about retroactive application of a statute rather than prospective. And it also comes up only when the legislature has not included in the legislation an express statement of its intention about retroactive versus prospective application. Would you agree with me on that? That's when the court moves to a procedural versus substantive analysis, which we have said, I think, more than once in recent days, that is an analysis for the court to make and not for the legislature to pronounce. Am I right on that much so far? Okay.
Once again, you're right, Justice Breyer. That it is.
That's really the whole reason.
You do that analysis when the statute is silent on whether it's
right.
applies retroactive or not.
Really. And that's because the defendant has a right under the Constitution, an ex post facto right under the federal Constitution, not to have the statute retroactively applied if it will disadvantage him, and that's a highly summarized version of ex post facto law, as you know.
Correct.
Okay,
But-
so when we're in prospective land, and the legislature has made an explicit statement about its intention to be prospective, that in fact just reinforces the presumption that we always engage in, correct?
I think it does.
Okay.
Plus the fact that if the legislature had said, we're going to make this entire criminal code retroactive, I think the court would have ex post facto problems with that, saying that something that wasn't a crime before
Sure.
July 1 of 2011 is now a crime.
Sure.
And,
Obviously, some sections would be problematic under ex post facto.
Right. And
Okay, I just wanted to make sure that we were clear and that my earlier question wouldn't be misunderstood. Because honestly, procedural versus substantive just doesn't matter here, does it? When
Right.
you have an express statement about prospective application, which is our presumption anyway.
yes,
Thanks.
that's correct. I think I've covered all the arguments that I wanted to
With,
make.
with respect to, Judge Ruddick did go through, the Gumby analysis on part of it that he allowed. What was the, disputed material fact or facts that justified admission?
I think he ruled that the evidence was admissible to show the relationship of the parties and the defendant's intent and motive. I think were the three things that he ruled admissible to show those things. And in one of the cases I cited on before, to show the relationship of the parties, I know I cited a case that talked about prior batteries between spouses is relevant to show identity, motive, and the relationship of the parties. And so that was the nature of the ruling, and I think that was based on case law at the time. And it also kind of rebutted the defendant's statement to the police that he just had this rosy relationship with the victim, and even though she was in her working clothes from working for a cleaning business, when she was found the next day, that they had consensual sex the night before. So I think it would still be relevant even after Gumby for those three things based upon the case law. For those reasons, the state would ask this court to affirm the defendant's conviction.
Do we have any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes rebuttal.
I'll just briefly note that the district court admitted evidence of the December 2006 abuse to prove the material facts of motive, identity, and discordant nature of their relationship, and that's volume 1, page 148. So not intent. I think there was discussion about intent, but identity. Yes.
Are you challenging discordant relationship or relationship of the parties as being a material fact that can be proved? We've said that the 8 in the statute are illustrative and not exclusive now.
I'm not challenging that, or I did not in my brief challenge that as something that this evidence can be admitted to prove. Like I did not try to exclude it as a category.
Why wouldn't it be relevant in this case then?
I don't think that it was in dispute that they had a discordant relationship. There's been statements that the defense was trying to show this as a rosy relationship, but Mr. Solis admitted that they had an argument that escalated to scratching each other. There was evidence of arguments and him showing up outside her work. So there was evidence that there was a discordant relationship. It was not in dispute.
So when defendant admitted that he had hit the victim that night, that made their relationship not material or not disputed? Is that what you're arguing?
Yes. The argument is that it wasn't in dispute whether they had a discordant relationship. Also, I think that in order for the evidence of prior incidences of domestic battery to have any bearing on motive or identity, there's some evidence that was missing that would have made it relevant. It would have been relevant if there was testimony that domestic batteries typically lead to repeat incidences of violence, or domestic batteries typically lead to strangulation, but we didn't have any kind of testimony. The inference is, well, he hit her in the past, so he must have done this. I think we kind of all assume that domestic battery is a cycle that just continues and can escalate to severe violence. But there was no actual extra testimony. There was no evidence that that is in fact the case. And so without that, we're left with propensity evidence.
Any further presentation, counsel?
No, Your Honor.
Do we have any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time, the court is in recess for 15 minutes.